Dear ladies and gentlemen, my name is Vanballegooij. I'm a policy advisor on civil liberties, justice and home affairs in the European Parliament. Furthermore, I'm about to complete a PhD covering judicial cooperation in criminal matters between the member states of the EU. I was asked to speak to you today about the approximation of procedural rights of suspects and accused persons in the European Union. I will do so in three parts. In the first part, I will outline the rationale for the approximation of these rights. In the second part, I will tell you about the current status of the negotiations. And in the final part, I will reflect upon the next steps to be envisaged. You will find more presentations on the topic, so my focus will be on the role of the European Parliament and the practical experience I have gained on negotiating legislation from its side. When looking at the rationale for making procedural rights more compatible among member states, perhaps it would be good to start with a short introduction to the role of the European Union in the area of criminal justice, as it has developed through consecutive treaty changes and policy programs. After this, I will talk shortly about the first comprehensive Commission proposal launched in 2004. Then, I will outline the roadmap on procedural rights as adopted in 2009 and the contribution that the European Parliament has had or made so far to the negotiations on the legislation proposed. The EU's involvement in the area of criminal justice proper is relatively new and to a certain extent still unknown to many. As with many policy areas of the EU, however, the seeds for its involvement were already sown in the founding treaties. Clearly, what was aimed for in the 1957 Rome Treaty was not an EU criminal justice area. Still, the development of a common market had implications for criminal law as a means of enforcing its policies. At the same time, it became increasingly clear that open borders, which are the ultimate aim of a common market, would necessitate cooperation between police and judicial authorities of the member states. This cooperation was originally organized outside the Union's framework, in accordance with the Schengen Conventions. However, since the entry into force of the Amsterdam Treaty in 1999, we are working towards a common EU criminal justice policy, aimed at the EU being an area of freedom, security and justice. The concept of an area might sound to some as implying that we need to develop a separate code of criminal law and procedure, with a separate prosecutorial capacity at an EU level. This has, however, not been the preferred policy option of the member states so far. Instead, they have sought to implement an EU criminal justice policy based on mutually recognizing judicial decisions and approximating criminal law and procedural rights to the extent necessary to facilitate judicial cooperation. To a large extent, this approach copies that of the common market, where free movement is supported by minimum environmental, health and safety standards. We have to realize that the last decade has been dominated by the aftermath of the 9/11 attacks on New York and Washington, which has expedited negotiations regarding extradition and other types of mutual legal assistance based on the principle of mutual recognition, with the European arrest warrant being the most important measure. At the same time, a Commission proposal aimed at guaranteeing basic fair trial rights of suspects and accused persons, as laid down in the European Convention on Human Rights, including the right to be informed of the charge, the right to a lawyer before questioning, legal aid, translation and interpretation, was subject to protracted negotiations between 2004 and 2007. The member states claimed that the EU legislation foreseen did not properly respect the differences in the way procedural rights are guaranteed, and that they would entail high costs to implement. The European Parliament, which supported the Commission proposal, could not play an active role in the negotiations, as it merely needed to be consulted by the member states at the time. Then, in 2009, the Commission and member states agreed to an alternative approach, in accordance with a roadmap, in accordance with which only one right at a time would be negotiated, starting with the right to interpretation and translation, which is called Measure A, followed by the right to information in criminal proceedings, Measure B, the right to legal advice and aid, Measure C, the right to communicate with consular officials and a third party. Measure D, the right of vulnerable suspects. Measure E, and finally, a green paper on prison conditions, particularly pre-trial prison conditions. Moving to the current status of negotiations. It's that we have adopted legislation on translation and interpretation and the right to information. Furthermore, negotiations are ongoing concerning a proposal which combines the right to access a lawyer and the right to communicate with consular officials and a third party, but it leaves out legal aid. The Commission has also adopted a green paper on prison conditions, to which the European Parliament responded with a resolution adopted in December 2011. As for the negotiations, the European Parliament has played an active role. That is because since the entry into force of the Lisbon Treaty, it is now co-legislator with the Member States in the area of criminal justice. Another important fact influencing negotiations has been the incorporation of the Charter of Fundamental Rights and the pending accession of the EU to the European Convention on Human Rights. A first assessment of the negotiations conducted so far is that, for right or for wrong, Member States continue to be very keen to highlight differences in the way they guarantee procedural rights of suspects. They have tried to make EU legislation compatible with the differences among themselves, particularly as regards the concepts of crime, suspect, and the point-in-time legal assistance and other substantive rights need to be granted. The Parliament, in its turn, has responded by having a close look at the compatibility of the positions taken by Member States with the case law of the European Court of Human Rights and procedural rights laid down in the before-mentioned Charter of Fundamental Rights. Often, the result of the negotiations have been vague formulations as to the timing and the substance of rights, something which undoubtedly will need to be fleshed out in national implementing legislation and may ultimately be the subject of Court of Justice deliberations. When talking finally about the next steps, it is perhaps good to remind ourselves of the fact that the Union strives for common minimum procedural rights that have to be in line with its fundamental rights obligations and be a basis of judicial cooperation among Member States. It is currently likely that negotiations on the right of access to a lawyer and future proposals on legal aid and the right of vulnerable suspects will be protracted. In the meantime, violations of fair trial rights, including the right not to be subject to inhuman and degrading treatment due to poor prison conditions, do occur on an everyday basis in the Member States. If not remedied properly, it will only be a matter of time before a court in one of the Member States, the European Court of Human Rights or the EU Court of Justice, will have to step in and hold judicial cooperation. I hope it doesn't come that far. Thank you for your attention.